All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome. Before we start, I would like to give the photographers the possibility to take some pictures. Please proceed. Thank you. Pursuant to Rule 124, Paragraph 1 of the Rules of Procedure and Evidence before the Kosovo Specialist Chambers, I hereby open this trial. Madam, or Mr. Court Officer, please call the case.
Your Honors, this is case file KAC BC 2020-04, the Specialist Prosecutor versus Pjetër, Shala.
Thank you. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules which we should adhere to all. Please, before speaking, make sure your microphone is activated and switch it off as soon as you finish. Speak slowly and clearly. We have interpretation from and into Albanian and Serbian, and in this way the interpreters can do their work properly. Before intervening, kindly wait 5 seconds in order to allow the interpreters to finish the interpretation of the previous sentence. I would like to remind you that this hearing is held in open session unless otherwise requested by the parties and Victims' Counsel or decided by the panel. And this applies in particular to the opening statements we are to hear about today and tomorrow. I kindly ask the parties and the Victims' Counsel to present their opening statements as much as possible in public and to rely on visual aids and material that can be broadcast to the public. That said, identification evidence such as photographs of the alleged crime and of the accused should not be broadcasted to the public in principle. I would like to remind the parties that certain information is subject to protective measures and confidentiality orders. That information cannot be disclosed. If parties and Victims' Counsel would have submissions that require to disclose this confidential information, please inform me about that, and then we can go into closed or private session. I will now briefly refer to the procedure that the parties and Victims' Counsel should adhere to follow, to request in-court redactions. Any request by the parties and Victims' Counsel during the hearing to redact part of what was inadvertently said in public session should be made via email so as not to attract undue attention to any confidential information. This email shall be sent to the address of the panel, copying the court officer and representatives of all the other entities present in the courtroom. Yeah? The request must clearly identify the words to be redacted, the timestamps, pages and line numbers of the real-time transcript. And such request must be made as soon as possible and no later than 15 minutes after the information was received. The entities present in the courtroom shall have 5 minutes to object, if they so wish, of course, and subsequently I will rule on the request. Yeah? The usual procedure. Should the parties and Victims' Counsel consider it necessary to go into private session, that's also possible if an explanation would be faster or more appropriate to make an oral request. This procedure is without prejudice to the panel's proprio motu power to decide on the need for any redactions, and any applied in-court redactions is also without prejudice to a subsequent revised assessment by the panel. And now I would kindly ask the parties and Victims' Counsel to introduce themselves, and we will start with the Specialist Prosecutor's Office. You have the floor.
Good morning, Your Honors. For the Specialist Prosecutor's Office, Alex Whiting, Acting Specialist Prosecutor, Line Pedersen, our Case Manager, Giulia Bianchi, our Legal Intern, and then Gaia Pergolo, Eva Wheeler, and myself, Filippo De Minicis, Associate Prosecutors.
Thank you. Good morning to Your Honours and to everyone. I'm Simon Laws and I represent the victims in this case, together with my co-counsel Maria Radziowska and my legal associate Kietwei Ung.
Thank you. Yes, now I turn to the counsel. You have the floor of the defense.
Thank you very much, Your Honours. So I'm Mr. Jean-Louis Gelissen, lead counsel from Belgium. We are here with Mr. Peter Shala, who is an important one in this procedure, of course. And I'm proud to present you Mr. Edea Winnie, co-counsel, you know him. Ms. Letu Kariolu, co-counsel. Mr. Winnie comes from Tunisia and France. Mrs. Kariolu comes from Cyprus. We are here with Mrs. Katerina Sharitu, legal officer from Cyprus. Zaneta Petrovica, case manager from Latvia. With Kaylin Chen, assistant legal officer from China. Juliette Healy, evidence review assistant, Ireland and France. Francisca De Castro, evidence review assistant, Colombia, France. And Judith Kolb, evidence review assistant from Germany. Thank you very much.
Thank you, counsel. Now I turn to the registry. Please, you have the floor.
Good morning, Your Honours. It's Ralph Roach from Judicial Services Division in the Registry. Thank you.
Thank you very much. And for the record, my colleagues for trial panel 1 are Judge Roland Dekkers, Judge Gilbert Biti, and Judge Vladimir Mikola. And my name is Mappi Veldfolia. I will first start with giving an oral order by the panel. The defense has raised an objection to any references being made by the Specialist Prosecutor's Office and Victims' Counsel to the accused prior statements given as a suspect to the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia. That was in 2005 and 2007. And also to the Belgian Federal Judicial Police in 2016 and 2019. The defense argues that their admissibility is currently under appellate consideration. The statements were taken in breach of the accused rights, and referring to them would be inappropriate, unfair, and unduly prejudicial. The defense objection was communicated to the panel, the SPO, and Victims' Counsel via email on the 15th of February 2023 at 36 minutes past 10. The panel has taken notice of the SPO's and Victims' Counsel responses on this matter, which were communicated to the panel, the parties, and Victims' Counsel via email on the 16th of February 2023 at 40 minutes past 1 and 43 minutes past 3, respectively. The panel recalls that on the 6th of December 2022, it issued a decision concerning prior statements given by Pjetër Shala. This is filing 364, in which it ruled that the material relating to the accused's ICTY interviews is admitted into evidence, and 2, the material relating to the accused's interviews with the Belgian authorities is not inadmissible and therefore can be considered by the panel in accordance with Rule 139, paragraph 1 of the rules. The panel further recalls that on the 24th of January 2023, it granted the defense leave to appeal the aforementioned decision on 3 issues. That's filing 401. And the defense filed its appeal on the 13th of February of this year, which is filing 4 EA 006. The panel also recalls that, in accordance with Rule 171 of the rules, interlocutory appeals shall not have suspensive effect unless otherwise ordered, and the defense had not made a request to this effect. Accordingly, the panel finds that the parties and victims' counsel can refer to prior statements given by the accused during their opening statements. Mindful of the ongoing proceedings before the Court of Appeals panel, the panel instructs the parties and victims' counsel, when making reference to the accused's prior statements, to note the fact that the issue of their admissibility is currently under appellate review. And this concludes the panel's oral order. Today's hearing is dedicated to the procedures as set out in Rules 124 and 125 of the rules, and the opening statements of the Specialist Prosecutor and Victims' Counsel pursuant to Rule 126 of the rules. The opening statement of the Specialist Prosecutor's Office and Victims' Counsel will be heard in 2 or 3 sessions. We start this morning at 9:30 till 11, then we have a break, then we proceed from 11:30 till 1 o'clock, and if necessary, there will be another break, and then we will restart at 2:30 if needed till 4 o'clock. Yeah? Tomorrow we will have the opening statements by the defense. The defense has informed us that Mr. Shala intends to make an unsworn statement, following the conclusion of the opening statements of the defense. I see a specialist counsel for the defense nodding. Before we begin with the procedure in Rule 124 and 125 of the rules, I will give a short procedural history in this case. On the 12th of June 2020, the pretrial judge issued the decision on the confirmation of the indictment against Mr. Shala, and also granted the request for an arrest warrant and a transfer order for Mr. Shala. On 16 March 2021, the accused was arrested in Belgium and was transferred on 15 April 2021 to the detention facilities of the specialist chambers in The Hague. On the 18th of October 2021, the pretrial judge granted in part the defense preliminary motion alleging defects in the indictment and ordered the SPO to file a corrected version of the confirmed indictment, and that was done by the SPO on the 21st of November of 2021. Then, on the 21st of September 2022, the pretrial judge transferred the case to Trial Panel 1. The 26th of January of this year, the panel set the date for the commencement of the trial for today, 21st of February. And both the pretrial judge and the panel have issued decisions on the participation of victims during the proceedings and reparations. And there are now 8 victims participate to the proceedings in this case. And now, the procedure as set out in Rule 124 of the rules, paragraph 2, requires that the trial shall proceed with the reading by the specialist prosecutor of the confirmed indictment by the pretrial judge. And as it was determined in our decision on the commencement of the trial, we think as a panel that it is sufficient for today's, the purpose of today's hearing, to read out the charges as stated during the initial appearance of Mr. Shala. Mr. Prosecutor, you have the floor.
Thank you, Your Honors. The accused, Mr. Pjetër Shala, is charged with 4 counts of war crimes. Count 1, arbitrary detention as a war crime committed at the Cookes Metal Factory between approximately 17 May and 5 June 1999, punishable under Article 14(1)(c) of the law on the Kosovo Specialist Chambers. Count 2, cruel treatment as a war crime committed at the Cookes Metal Factory between approximately 17 May and 5 June 1999, punishable under Article 14(1)(ci) of the law on the Kosovo Specialist Chambers. Count 3, torture as a war crime committed at the Cookes Metal Factory between approximately 17 May and 5 June 1999, punishable under Article 14(1)(ci) of the law. Count 4, murder as a war crime committed on or about 5 June 1999 at the Cookes Metal Factory, punishable under Article 14(1)(ci) of the indictment. The accused is charged with these crimes pursuant to Article 16(1)(a) of the law under 3 modes of liability. First, he is charged as a participant in a joint criminal enterprise, the common purpose of which was the commission of the crimes of arbitrary detention, cruel treatment, torture, and murder, as charged in counts 1 through 4 of the indictment. The accused is charged with having possessed the intent for each one of these crimes. Alternatively, it was at least foreseeable to the accused that the crime of murder could be committed as a consequence of the furtherance of the common purpose, and he willingly took that risk. Second, the accused is charged as a physical perpetrator of the crimes of arbitrary detention, cruel treatment, and torture, as charged in counts 1 through 3 of the indictment. Finally, the accused is charged as an aider and abettor for all crimes charged under counts 1 through 4 of the indictment. And this, Your Honors, concludes the reading of the charges.
Thank you, Mr. Prosecutor. Mr. Shala, please stand up. Mr. Shala, I trust you understand the nature of the charges brought against you. Is that correct?
Yes, I understand, but I do not accept anything. It's all fabricated. Everything is fabricated.
Opportunity to give an unsworn statement. Thank you. And Mr. Shala, during your initial appearance on the 9th of April 2021, you pleaded not guilty to all counts of the confirmed indictment. You have now the opportunity to confirm this plea. Do you confirm this plea?
Fully not guilty.
Mr. Shala, let me inform you of some important rights that are afforded to you before this court pursuant to its legal framework. You have the right to remain silent, and any silence being, and no silence being a consideration in the determination of your guilt or innocence. You have the right not to be compelled to confess guilt or to testify. You have the right not to incriminate yourself or your immediate family members. You have the right to be represented by a counsel, and I note that you are represented by Specialist Counsel Mr. Gillison and the co-counsels Mr. Ayuni and Mrs. Cariolo. You have the right to adequate time and facilities to prepare your defense and to communicate with your counsel. You have the right to be tried within a reasonable time. You have the right to examine or have examined witnesses against you and to obtain the attendance and examination on witnesses on your behalf. You have the right to make an unsworn statement regarding the case and also to appear as a witness under oath. And I also must inform you, according to Rule 61, Paragraph 2 of the rules, that I can order your temporary removal from the courtroom should you adopt disruptive behavior during the proceedings. Yes? We will now proceed to hear the opening statements. And I saw, Mr. Shala, that you wanted to say something. We will give you the opportunity tomorrow, when your defense counsel has concluded the opening statements, to give your unsworn statement. You will be given the opportunity to speak. Yes, the opening statements. We will first hear, as said, the opening statements by the Specialist Prosecutor's Office, then followed by Victims' Counsel. The decision on the commencement of the trial had indicated 2 hours each for each opening statement. We were informed yesterday evening by the Specialist Prosecutor's Office that they have done a reassessment of the duration of their opening statements, and that for now it's estimated on 1 hour and 15 minutes. Yeah. I see Mr. Prosecutor nodding. That is noted. Mr. Prosecutor, you have the floor.
Good morning, and may it please the court, your honors, counsel. As acting specialist prosecutor, it is an enormous privilege to be able to address the court at the beginning of this trial. Before I turn to the case at hand, allow me to say a few words about where we find ourselves at this moment as an institution. We have had many milestones and many firsts at this tribunal. First indictment, first arrests, first pretrial hearings, first trial, first judgment, first sentencing, first appeal. We are now past all of those firsts, and we are in a different phase. We are now a fully functioning, well-established, proven institution. An institution that has demonstrated that it can deliver, that it can adjudicate cases within its mandate both fairly and efficiently, even under what are often extraordinarily challenging circumstances. Credit for this accomplishment goes to the states that established this court and that have continued to support it. Credit also goes to the hardworking and dedicated staff members of this institution, the staff of the Specialist Prosecutor's Office, the President's Office, Chambers, the Registrar, the victim's representative, and the defense. But most of all, Your Honor, credit is due to those in Kosovo who have supported the work of this court, and in particular the victims and witnesses who have shown tremendous courage in coming to this courtroom and sitting in that chair to give their evidence. The judges of this court have found repeatedly in judgments, decisions, and orders that there continues to exist a climate of witness intimidation in Kosovo. It is real, it is serious, it is pervasive, and it is ongoing. Our office and this institution have again and again acted to counter this climate by protecting witnesses and by taking measures against anyone who illegally seeks to undermine this institution or to intimidate witnesses. And we will continue to do so. We will continue to use all available means to ensure that witnesses can come to this courtroom to provide their evidence safely and securely. Nonetheless, Your Honors, there is no doubt that this persistent climate of witness intimidation will continue to shape and affect this trial. It will weigh on the witnesses as they come into this courtroom to testify. It is a climate that they and their families live in every day. It is a reality that they must return to. And therefore, as Your Honors listen to the witnesses who come into this courtroom during this trial and sit in that chair, as Your Honors consider their words and assess their credibility, we will always ask you to keep in mind the circumstances under which they are testifying, the persistent climate of fear and intimidation, and the effects that this climate might have on their testimony. Ultimately, Your Honors, the success of this institution is a success for Kosovo. Opponents of this court have repeatedly sought to claim that it is anti-Kosovo and anti-KLA. But nothing could be further from the truth. This is a Kosovo court created by the Kosovo Assembly with international support and cooperation that sits within the Kosovo legal system. The cases brought in this court are not against Kosovo, and they're not against the KLA. They are brought against individuals who are alleged to have committed crimes during the war. Moreover, in all of the cases charged at this court, Your Honors, including this one, a majority of the victims are Kosovar Albanians, and in some cases, all the victims are Kosovar Albanians. This court affirms the principle of the rule of law in Kosovo, including the rights of persons accused of war crimes to receive a fair trial. And it emphasizes that nobody is above the law and that those persons accused of committing international crimes can be held to account no matter what cause they are fighting for. That principle, Your Honors, applies to all armies, including the KLA. Let me be clear on this point. The righteousness of one's cause or the belief in one's cause, no matter how strong that belief might be, does not provide immunity for those who violate the laws of war and commit war crimes. They are accountable to the law, just like everybody else, regardless of their cause. The case that begins today, Your Honors, against the accused Pjetër Shala is actually very straightforward and simple, even if it tragically altered the lives of many and ended the life of one. The evidence will show that in the spring of 1999, in Kukës, northern Albania, the accused committed the war crimes of arbitrary detention, cruel treatment, torture, and murder. The evidence will further show that Mr. Shala was part of a small group of KLA soldiers that committed these crimes. The group included Sabit Getsi and Shemshet Kresnici, both of whom were already convicted in 2 trials in Kosovo for arbitrary detention and mistreatment at the Kukës metal factory. The indictment in this case alleges that this criminal group that included the accused detained and severely mistreated at least 18 victims in the detention center located within the former metal factory in Kukës. This criminal group, including the accused, murdered one of those victims on or about the night between 4 and 5 June 1999. The victims in this case were targeted because of their perceived affiliation with the Serbs, considered spies or collaborators that deserved punishment and humiliation. They were detained without any legitimate process whatsoever, and while they were held in detention, they were subjected to severe and repeated abuse, torture, and in one case, murder. Let's be clear here. The intentional abuse of detainees during an armed conflict is a war crime, pure and simple, and can never be justified under any circumstances. There is no justification for abuse, torture, and murder of detainees. The laws of war do not permit it, not for this conflict, not for any conflict. The accused Pjetër Shala participated in all aspects of the crimes alleged in this case. He was present at the Kukës metal factory at significant times during the period of the indictment. He participated in at least one arrest and transfer of a prisoner to the detention facility. He contributed to maintaining the inhumane conditions of detention at the facility, which included crowded and dirty rooms and inadequate food. He participated in repeated and severe beatings of prisoners at the detention facility that included beatings with iron bars and sharp objects. As a result of these beatings, victims were left covered in blood, suffering from broken bones, or unable to walk. The accused was also part of the group that murdered one of the detainees by beating him repeatedly and severely and shooting him in the leg, causing him to bleed to death over a period of many hours. In a moment, the trial team will provide more detail about the circumstances of these crimes, the layout and the background of the Kukis metal factory, the connection to the armed conflict, and the responsibility of the accused. But before I cede the floor to the team to continue with the opening statement, one final point. There is one thing that the prosecution and the defense in this case agree on, and that is that the prosecution and the prosecution alone bears the burden of proving these allegations beyond a reasonable doubt. That is a burden we accept, we welcome, and we will meet. The defense bears no burden and is entitled to remain silent throughout these proceedings. But, Your Honors, the defense has not remained silent. And to the extent that the defense has taken positions on the factual allegations, the trial panel is entitled to consider them when evaluating the evidence. And in this case, the defense has denied everything. The accused did not arrest or transfer anyone, did not participate in detaining anyone, did not maintain inhumane conditions, did not abuse any prisoners, none, and was not even at Kukis when the detainee was murdered. As far as the accused is concerned, none of it ever happened, none of it. When Your Honors listen to the witnesses called by the prosecution and review the statements submitted into evidence, keep in mind, Your Honors, these complete denials by the accused in this case. Why is he now claiming no connection whatsoever to what happened at Kukis? Why is he trying to distance himself as much as he can from what happened at Kukis? And to the extent the trial panel considers Mr. Shala's prior interviews, whose admission into evidence has been challenged by the defense and is now being considered by the appeals panel of this court, and which will be discussed in more detail at the end of the opening statement, you will want to consider whether the admissions made by the accused in those interviews are consistent with the denials he now makes in this case, now that he has been charged with the crimes. As will be explained in more detail now by my colleagues, we are confident that the evidence that will be presented during this trial will establish beyond a reasonable doubt that Mr. Shala is criminally responsible for the crimes charged in the indictment. Thank you, Your Honors. I now cede the floor to Ms. Pergolo, who will continue with the prosecution's opening statement.
Your Honors, during this part of the presentation, I will discuss the site where the crimes charged in this case were committed. First, I will provide some geographical and contextual information about the Kukës metal factory. Second, I will explain how the Kukës metal factory is connected with the armed conflict in Kosovo and how it was used by the KLA during the indictment period. Third, I will take you to virtually visit the site, stopping at specific locations where key events took place. Your Honors, I will now use a PowerPoint presentation. The first 3 slides can be broadcast to the public. The town of Kukës lies at the foot of a Gjalica mountain, overlooking the merging of the Black and White Drini rivers in the northern part of Albania, about 20 kilometers from the Kosovo border. The Kukës metal factory is situated in the outskirts of the town of Kukës, approximately 1.5 to 2 kilometers from the center of Kukës town, on the road going to Krum, as indicated by the red dot on the screen. Your Honors, as per your instructions, the rest of the SPO presentation is not to be broadcast to the public. This is a north-south view of the Kukës metal factory, with the road going to Krum on the right-hand side of this image. The Kukës metal factory had an entrance gate, accessible from the road going to Krum, and a guard booth to the left-hand side of the entrance gate. A command building, where KLA soldiers and officers were accommodated while staying at the factory. A number of warehouses, an internal courtyard, and a small building protruding inside the courtyard. The site is a former metalworks factory and was once property of the Albanian state. It was privatized in 1998, and witness 4379 became the owner, using it initially for private purposes. A few days after the NATO bombing began on 24th of March 1999, a KLA member asked 4379 to use the factory, to which he agreed. The KLA used the factory for 3 months, until approximately June or July 1999. The Kukës metal factory was used during and in connection with the armed conflict that existed during the indictment period between, on the one hand, the Serbian forces, in particular forces of the Army of the Federal Republic of Yugoslavia, VJ, and the Ministry of Interior of Serbia, MUP, and on the other hand, the Kosovo Liberation Army, KLA. The existence of the armed conflict during the relevant period has been established by other courts, the ICTY in particular, and by this panel in the case Specialist Prosecutor versus Salih Mustafa. In that case, this panel found that at least as of the end of May 1998, the armed hostilities in Kosovo between the Serbian forces and the KLA had the requisite level of intensity to be considered an armed conflict. This panel also endorsed ICTY findings that as of May 1998, the KLA possessed a sufficient level of organization to be able to engage in a non-international armed conflict. The Djordjevic trial chamber at the ICTY and the Supreme Court of Kosovo in the Latif Gashi case also found that the armed conflict in Kosovo continued during the period of the indictment in this case. As a result of the armed hostilities in Kosovo, between the end of March and May 1999, large numbers of refugees fled Kosovo and settled in the municipality of Kukës. Some of those refugees ended up in the Kukës metal factory, which, as mentioned before, was controlled by the KLA during that period. The Kukës metal factory was used as a base for recruitment, mobilization, and logistics. KLA recruits were provided with weapons and uniforms, then sent for training before joining the front line. In addition to being used to further the KLA's war efforts, the Kukës metal factory was also used to detain, interrogate, and mistreat individuals considered spies and collaborators of Serbia. The individuals who were imprisoned in the Kukës metal factory arrived there for a variety of reasons and in many different ways. Some came to the factory voluntarily. Others were taken there forcibly. For example, trial witness 401 traveled to Albania in May 1999. Upon arrival to Kukës, he went to the Kukës metal factory. Your Honors, a terrible fate was awaiting him. As the evidence will show, trial witness 401 was subjected to ill treatment, torture, and beatings because he was suspected of being a spy. Trial witness 411 left the Kosovo municipality of Prizren in March 1999, together with his family, due to attacks by the Serbian forces. He traveled to Albania on foot and settled in a refugee camp in Kukës in April 1999. About a month later, in May 1999, trial witness 411 was approached by two KLA members who told him he had to provide a statement, at which point he was taken to the Kukës metal factory and detained there for about a month. Witness 4733 fled Kosovo in April 1999 with his family. As a refugee in Albania, he did not encounter a better fate, as he was kidnapped by KLA members in May 1999 and taken to the Kukës metal factory. There, he was subjected to ill treatment and torture, as he was accused of not resigning his job as a police officer in the Serb institutions in the 1990s. Your Honors, the evidence will show that all of the individuals who were detained in the Kukës metal factory were civilians, not taking active part in the hostilities. The perpetrators were all KLA members, including the accused, Pjetër Shala. Your Honors, I would now like to show you, with the assistance of visual aids, some of the locations inside the Kukës metal factory where key events took place. To do so, I will use a 3D model of the Kukës metal factory that the SPO has previously shared with the panel, Defense Counsel and Victims Counsel. This 3D model has been created for the purposes of this presentation only, on the basis of old and new cadastral maps of the Kukës metal factory, as well as photographs the SPO has taken during visits to the site. It is used here just to give everyone in this courtroom an impression of the site itself, of where certain buildings are positioned and where they stand in relation to one another. Next to each rendering of the 3D model, pictures of the metal factory will be shown. We will start with an aerial view of the Kukës metal factory you are already familiar with. As this image fades away, you will see the 3D model appear in an aerial view. We will now zoom into the factory and approach the entrance gate. You can see a photo of the entrance gate on the left-hand side of the screen, next to the corresponding part of the 3D model rendering. We will then enter the premises and look to the left-hand side to see the guard booth and what we will refer to as the command building. Moving now into the internal courtyard, we first have a view of the command building from the northwest corner. And then, turning on the left-hand side, we have a frontal view of the command building. The command building is a concrete structure with 2 floors, which inside are different rooms used as offices and accommodation for the KLA soldiers. There was also a pharmacy and an office where a so-called KLA prosecutor or judge interrogated those suspected of collaboration. The evidence will show that some witnesses, including 4733 and 1448 were detained in this building in May 1999, interrogated and ill-treated. Further, in this building, some of the most brutal beatings happened on or around 20 and 21st of May 1999, when 4733, 1448, trial witness 401, and the murder victim were tortured by certain KLA members, including the accused. Moving now away from the command building, we will turn to our right-hand side, moving clockwise inside the metal factory to see one of the warehouses across the courtyard. As we continue, we will see a smaller building protruding inside the courtyard. The 3D model shows how the structure was at the time of the events, as it can also be seen in this picture. Since then, this building got partially destroyed, now looking like this. The arrow shows that the part made of red bricks that still stands today corresponds to the furthest part of the building as it used to be. The evidence tendered by the SPO will show that the victims were held in this building, which we will call the detention building, throughout their detention in the Kukës metal factory, in poor conditions and subjected to torture and ill treatment. Crucially, this is also where the murder victim was brutally assaulted, beaten, shot, and killed on or about the night between the 4th and the 5th of June, 1999. Finally, in the warehouse opposite the detention building, which we can see here on the right-hand side of the 3D model and on the picture, the toilets were located. The witnesses that the SPO will call to testify will explain that they were harassed when they left the detention building on their way to the toilets. We will now leave the site and go back to the initial cadastral map of the Kukës metal factory. Your Honors, this concludes my part of the presentation. My colleague Eva Wieler will now present to you the evidence that the SPO will rely on to prove the charges in this case. Thank you.
The evidence the SPO will show in this case will leave no doubt that the charged crimes occurred at the Kukës metal factory at the times relevant to the indictment. Your Honors will hear and see evidence of how victims were abducted and brought for detention to the Cookus metal factory, including by some of the victims themselves. The victims will testify about their detention at the Cookus metal factory, the people they recognized there, the inhuman conditions of their detention, the torture and cruel treatment they suffered there, and who their tormentors were. They will report on the severe physical and psychological injuries inflicted on them, some of which continue to affect the victims and their families to this day. The targeted individuals were almost exclusively of Kosovar Albanian ethnicity and some of Roma ethnicity. They were all civilians. They were abducted, detained, and mistreated on the suspicion of being collaborators. None of them, though, at the time of their arrest, took part in any of the hostilities. Some of them just arrived to Albania from Kosovo. Others actually supported the KLA with donations and food supplies. And again, others just wanted to stay out of the war. None of the detainees were given any valid reason as to why they were detained, and no arrest documents were provided to them. Witness 4733, a Kosovar Albanian living with his family in Sermian in the municipality of Jakov, was one of these victims. He had left Kosovo for Durrës, Albania in April 1999. Shortly after their arrival, KLA members started to repeatedly visit the home where witness 4733 and his family had found shelter, trying to kidnap him. In mid-May 1999, the KLA military police succeeded and abducted 4733. They kept him in Romanat, Albania, for 3 days, and then handed him over to the accused, alongside with other KLA members, to be transferred to Cookus. They brought 4733 to the Cookus metal factory late in the evening on or about 20 May 1999. He was brought into the command building, the building right to your left-hand side, once one entered the main entrance gate to the premises. They put him into an improvised cell, dirty, narrow, and with no daylight. There he met witness 1448, who had been kept in this very cell at Cookus for some days already. The night of 4733's arrival at the Cookus metal factory was also the night brutal beatings at the command building are reported by the victims in this case, including 4733. Shortly after being brought to his cell, 4733 was taken to another room in the command building, where he was met by a group of KLA soldiers, including the accused. 4733 was asked to confess to the murder of hundreds of Albanians, to the raping of women, and he was asked to sing a Serbian song. Then they started to beat him with their fists, a baseball bat, sticks, rubber batons, and the barrel of a revolver. They cut his wrists. They burned him with cigarettes. They poured salt into his wounds, and they broke his teeth. 4733 was brutally beaten until he lost consciousness. Once he regained consciousness, he was wet from the water that was poured on him to bring him back. And the beatings continued. Eventually, other detainees were brought into the room. Witness 1448 and trial witness 401 found 4733 covered in blood, and they witnessed the further beatings inflicted on him while being mistreated themselves by the accused and his associates. One detainee was told to beat 4733, and when he refused to do so, he was severely beaten up himself. Once the accused and his associates were finished with 4733, they dragged him out of the room, as 4733 could not walk anymore. In the hallway, the mistreatments continued until he was dragged back to his cell. As he was being removed, the beating of other prisoners, including trial witness 401 and the murder victim in this case, started. As they were abusing their victims, the perpetrators accused them of having personal or professional ties and relations with Serbian institutions or individuals. The beatings lasted until the next morning and caused severe physical harm, extensive bleeding, and extreme pain to the victims. A few days after the night of the brutal beatings in the command building, 4733 and his co-detainees were brought from their cell in the command building across the courtyard into the detention building. You were shown a photo of the detention building during the virtual site visit, and you also heard that the building has been demolished in the meantime. There, they joined another group of detainees. The detention building had 3 rooms. 2 of them were used to keep detainees. About 9 detainees were crammed into one of these rooms. The room had barred windows. It was locked and guarded by KLA soldiers. The detainees could not leave the room except for 4 of them, which were subject to forced labor, forced to clean dirty toilets, and to load and unload the trucks that arrived for the KLA at the Kukës metal factory. To use the bathroom in the other building, the detainees had to ask for permission. The toilets the detainees were allowed to use were in a very poor hygienic status, and on the way there, they were regularly harassed by KLA soldiers. One of them, for example, tried to stab the detainees with a knife while they were crossing over from the detention building to the building with the toilets. The detention room had no furniture, no beds, and no mattresses. The detainees tried to sleep leaned against the walls or on the sandy floor. They received drinking water, but food was scarce for them, and they were provided no or inadequate medical care. The physical and psychological abuse by the accused and other KLA members continued also after the night of the brutal beatings in the command building on or about 20 May 1999. Thereafter, witness 4733 and his co-detainees were regularly subjected to beatings, humiliations, interrogations, and threats. Some victims were singled out and subjected to particularly harsh treatment and severe injuries. Trial witness 401 was one of them. The accused personally participated in his mistreatment on at least 10 separate occasions. During one of them, trial witness 401 was ordered to put on a bulletproof vest and was shot at with an automatic weapon, leaving 401 with severe pain, trauma, and trouble breathing. One prisoner did not survive his detention and the torture he suffered at the Kukës metal factory. On 4 June 1999, the murder victim of this case and trial witness 401 were removed from the room where they were kept in the detention building. They were savagely beaten and shot at by a KLA member. The murder victim was shot at his leg. He was only provided very basic medical care. KLA personnel refused to take him to a hospital. Instead, they continued to humiliate and threaten him. As a consequence, the murder victim bled out that night and died on or about 5th June 1999. During this trial, your honors will be presented with the accounts of those who survived the detention at the Kukës metal factory. They survived and were released either because of personal ties and relationships, or they were freed by the German KFOR in mid-June 1999 after they were transferred to the police station in Prizren. None of the detainees were ever referred for any judicial review or adjudication of their detention. Witness 4733 was released due to the intervention of the Albanian intelligence service in the beginning of June 1999. When he returned to his family, they barely recognized him. Being detained in Kukës was not only traumatizing for the victims, but also for their families. 4733 was marked with scars and wounds from the mistreatments he suffered during his detention at the Kukës metal factory. He was unwashed, bloodstained, and had lost a lot of weight. 4733 suffered from the physical and psychological injuries he endured during his detention at the Kukës metal factory for the rest of his life. His family members will describe how once witness 4733 returned to them, they witnessed the signs of his mistreatments he had suffered and heard directly from 4733 the account of his ordeals. They will also testify about the effect that his detention in Kukës had on them and the burden it has placed on the entire family. Some of the evidence in this trial was provided by witnesses who are unavailable to testify in court during this proceeding, either because they are deceased or not fit to testify in court. The statements of these witnesses, however, are corroborated and supported by evidence of other witnesses who will testify before your honors in this trial. The evidence presented in the course of this trial will leave no doubt that the charged war crimes of arbitrary detention, torture, cruel treatment of several detainees, and the murder of one of them took place at the Kukës metal factory during the indictment period. My colleague will illustrate now how the SPO will prove that the accused is criminally responsible for these crimes charged in the indictment.
Your Honor, before I start, I am mindful of the time. I believe that it will take me approximately 15 minutes to complete my presentation.
Mr. Prosecutor, I suggest that then you finalize unless you see that this 15 minutes become longer, because then we have all the time to do it after the break.
Will do, Your Honor. Your Honors, the accused, Peter Shala, is criminally responsible for the crimes charged in the indictment and just described by my colleague. The evidence will show that he was a member of a small criminal group of KLA soldiers that committed these crimes at the Kukës metal factory. The prosecution will present evidence showing that he is responsible for these crimes as a physical perpetrator, as a member of the joint criminal enterprise, and as an aider and abettor. In 1998, Your Honors, the accused was a member of the KLA in Jablanica, Kosovo. The accused was also known with the nickname of Uiku, which means wolf. This, as your honors will learn, is a significant detail. For instance, because 4733 recalls that the accused, as it was transporting him after his arrest to the Cook's Metal Factory, made a wolf-like howl. The accused was known to make such howling sound when he was in action. In the summer of 1998, the accused left the war in Kosovo and moved to Belgium. He remained there until approximately mid-March 1999, when he decided to make his way back to the region. He traveled to Albania, arriving in Durrës. Upon his arrival, he was told to go to Kukës and to join the 128th Brigade of the KLA in the Pashtrek zone. The accused was led to believe that he was going to acquire a sort of commanding role within that brigade. But upon his arrival, it became immediately clear to him that that was not going to be the case. Disappointed, the accused left approximately after a couple of days and went to the front lines at the border between Kosovo and Albania. And your honors may recall from the first slide presented by my colleague, which was publicly broadcast, that Cook's and the metal factory are not far from the international border. The accused remained there, operating in that area for several months thereafter. And several witnesses will testify that he was present at the Kukës metal factory during critical moments within the indictment period. As I said, your honors, the prosecution case is that the accused committed these crimes as a member of a small group of KLA soldiers, a small criminal group. He was not the commander of this group, but a direct participant who committed these crimes both personally and together with others. The accused's responsibility stems from his participation in acts that both initiated and maintained the arbitrary detention of the victims at the Kukës metal factory. He also extensively participated in their mistreatment. Mistreatment which eventually led to the killing of one of them. In this regard, your honors, while the accused did not formally hold a high rank within the KLA or within the Kukës metal factory for that matter, he enjoyed a high degree of freedom and action, which were instrumental to his criminal conduct. This included the ability to move in and out of the crime site as he pleased. Your Honor, in fact, the prosecution, and this I want to make it clear, does not allege the accused was present at the Kukës metal factory every day during the indictment period. But he was present when it mattered. He was present at critical times within the indictment period. This will become clear from the evidence of several witnesses in these cases, your honors. They include victims, such as 4733, trial witness 401, and 1448. They also include members of the Kosovo Liberation Army who were present and stationed at the Kukës metal factory during the indictment period. Finally, Your Honors, the accused's presence at the times relevant to the indictment at the Cookes Metal Factory is also clear from his own admissions and statements, which I want to recall these statements and their admissibility is currently under scrutiny before the appeals chamber. Your Honors, in these statements, the accused corroborated through his own admissions multiple important aspects of the prosecution case and of the evidence Your Honors will hear in this trial. For instance, Your Honors, importantly, the accused admitted to seeing trial witness 401 and the murder victims within the premises of the Cookes Metal Factory. As a matter of fact, he admitted to beating them. The accused also admitted to seeing 4733 in the factory. He did not have kind words in relation to that witness. Importantly, this is a significant detail, he admitted to seeing him wearing a uniform. Now, 4733 was wearing a uniform because after he was abducted in Albania, his family reported the abduction to the police. The police were looking for him. So the KLA, to transfer him to the Cookes Metal Factory and avoid being detected by possible roadblocks of the police, put him in a KLA uniform. They were pretending he was one of them. Your Honor, the accused was not only present at the Cookes Metal Factory. The evidence of several witnesses and his own statements will establish that he actively participated in the charged crimes. This participation was both significant and extensive. The following are just some examples of his participation. So, around the 21st of May 1991, approximately around that date, the accused participated in the transfer of 4733 to the Cookes Metal Factory. He did so together with other KLA members. As recalled, 4733 recalled that he was making a wolf-like howl during the transport. 4733 recalled that the accused did so on other occasions while at the Cookes Metal Factory. The accused, Your Honor, was the first person to hit trial witness 1 and the murder victims in this case after they were arrested at the Cookes Metal Factory. 1448-2 described the extensive involvement of the accused in the mistreatment of detainees at that site. Your Honor, my colleague, Ms. Wheeler, has described in detail the extremely violent beatings that took place on or around the night of 20 May 1999 in the common building at the Cookes Metal Factory. The accused was present in the room. We know this from the evidence of multiple witnesses. Together with other KLA members, including members of the Joint Criminal Enterprise, he savagely beat trial witness 401, 1448, the murder victim, and 4733. All three witnesses, all of them, indicate that he was one of the participants to that brutal beating that took place throughout the night. Your Honors, the fear in the room that night is difficult to imagine. The accused and the others attacked and savagely beat the victims when they were at their most vulnerable. These people could not defend themselves. They were there, and they had to take whatever they decided to inflict on them. Your Honors, these, as I said, are just some examples of his participation in the crimes, which took other forms. For instance, we have evidence, and we will present this evidence, that he for instance, forced the detainees to perform forced and degrading labor while at the Cook's metal factory, thereby maintaining their arbitrary detention and cruel treatment. Your Honors, unfortunately, 2 of the victims, 4733 and 1448, have passed away. We will tender their statements in evidence. Your Honors, we submit this evidence is corroborated and reliable, as you will be able to appreciate in the course of the trial. Your Honors, in addition to denying any participation in the crimes, as recalled by Mr. Whiting, the defense has also repeatedly attacked both the investigation in this case and the credibility of one particular prosecution witness, trial witness 401. They say that this witness gave false testimony in the past, that he is not credible because he has a criminal record. Your Honors, trial witness 401 did give false testimony in the past. He recanted certain incriminatory statements and later explained why he provided falsely this exculpatory evidence. Your Honors, the witness will take the stand before you. We will address this issue. Your Honors will be able to question the witness about it. Trial witness 401, Your Honors, also has a criminal record. The prosecution is not denying that. But the fact remains, Your Honors, that he was also a victim at the Cook's Metal Factory. The 2 things, Your Honors, are not incompatible. Nor does his criminal record make him less deserving of justice. This witness, Your Honors, has provided several statements over the years. In these statements, he always consistently implicated the accused in his mistreatment and in the mistreatment of the other victims at the Cook's Metal Factory. Always. And Your Honors, in the end, it will be up to you to listen to this witness and assess his credibility in light of everything that happened to him and what he tells you. It will be up to you to assess his credibility when he will testify about having been victim of unspeakable acts of violence at the Cook's Metal Factory, perpetrated by the accused and by other members of the joint criminal enterprise. You will decide how and in what ways this evidence is corroborated by the evidence of other witnesses in this trial. And finally, Your Honors, you may also consider, depending on the outcome of the appeal, the accused's own statements and his very admissions that he beat trial witness 401, he beat the murder victim, and why he beat them. And in the end, Your Honors, you will decide whether TW, trial witness 401, is fabricating a story, as the defense now claims, or is telling the truth about the role that the accused had in the crimes charged in this case. Before I conclude, I just want to say a final word about these statements, Your Honors, which we have amply recalled are currently on appeal. Your Honors, as the trial progresses and you become familiar with the evidence in this case, I invite you to think about the admissions that the accused made in these statements, which he repeated over the years with regard to his role in the crimes he committed in Cook's. Your Honors, you will see that he only provided a partial account of his involvement in these crimes. He tried to minimize his responsibility, which is in fact much, much broader than what he was prepared to state. Through the statements and testimonies of his witnesses at trial, the SPO will probe the full scope of the accused's responsibility. In conclusion, Your Honors, this is a case of violence, cruelty, attacks against human dignity perpetrated in a period of a little over 2 weeks in a small location in northern Albania. It's not a complicated case. The crimes were committed by certain KLA members. The accused was one of them. His responsibility also encompasses the murder of the named victim in this case. The evidence the prosecution will present at trial will prove beyond reasonable doubt that the accused possessed the required intent for this crime. In the alternative, and at the very least, Your Honors, it was foreseeable to him that the murder could be committed. Think about the weapons that were used during these mistreatments. They were potentially lethal weapons that included batons, knives, and firearms. So it was entirely foreseeable to him that the victim could have died eventually, and by continuing to engage in that criminal enterprise, he willingly took that risk. In the end, Your Honors, through the evidence that the SPO will present at trial, the SPO will prove beyond reasonable doubt that the accused is guilty and criminally responsible for the crimes charged through counts 1 through 4 of the indictment.
Mr. Prosecutor, thank you, Specialist Prosecutor's Office, for the opening statements of this morning. It's now time for the break. After that, we will continue with the opening statements for the victim by the Victim Counsel, and at the end of your opening statement, I will discuss shortly the request made by the trial panel with regard to submissions to be made with regard to the video hearing for 3 witnesses. There's something I want to say about that. Okay. For now, the hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. I have a look at who's present, and I'm under the impression that there's no change in who's attending.
That's correct, Your Honors.
Thank you. And for the victim councils, it's the same.
The same, Donnie.
Yes, the registry. And here, are we in the same composition as defense counsel?
Good morning, Your Honor. Just to announce that we are joined by Mr. Mathias Langlais, Ms. Zoé Paris, and Ms. Zeynep. Her last name is a bit difficult for me. From Turkey. I am sorry not to be able to pronounce the last name. It's a bit difficult for me to pronounce. The three of them are new interns with us, and we wanted to give them the opportunity to attend. Thank you, Your Honor.
Thank you very much, and that is noted for the record. Yes, we have finalized the opening statements by the Specialist Prosecutor's Office, and it's now the turn for Victims' Counsel. Victims' Counsel, could you indicate how much time you estimate that you will be needing?
Well, we said initially up to 2 hours, and we're going to be shorter than that. I hope that it may be possible to do it in about an hour and a half, an hour and 40 minutes, something of that kind.
Okay. Let us see how we will proceed. After your opening statement, the panel wants to address still 2 issues before we conclude this
Yes.
hearing today.
If it assists, the last 10 or 15 minutes of the opening statement on behalf of the victims will be made by my co-counsel, so there'll come a natural break if that assists.
Thank you, because then in that way I think I foresee that we will break at 1 and then resume after lunch, because I think that if not, we will spill over too much the 1 o'clock break,
Well,
also for the interpreters.
Yes, of course. Well, let's see how we go. It may move more quickly, but those are our best estimates.
Very well. You have the floor.
Your Honour, thank you. And may it please the Court. The evidence in this case shows that in the indictment period, the Kukes metal factory was a place that temporarily existed beyond the rule of law. People were abducted and taken there. If they were already there, they could be locked away on the whim of a commander. There was no question of any review of their detention, still less of any appeal. Detention decisions were made arbitrarily, driven by spurious allegations of collaboration. Once detained, those in charge took the opportunity to interrogate their captives with intense brutality. They were beaten, burnt, and electrocuted. They heard each other scream, and they knew that they might be next. They were housed in harsh conditions, and their days and nights were full of suffering and fear. Their captors' sense of impunity, that they could act without consequences, emboldened them. Their cruelty grew. In the end, a man was killed. It was a senseless and pointless waste of a young life. The victims and others say that the accused, Peter Shala, played a part in all of these crimes. He and others with him persecuted those who were powerless and who were vulnerable to any kind of abuse which their jailers decided upon. Amidst all the barbarity and cruelty that we will hear about, the victims were not allowed to raise their voices. We will see references to them being forbidden to speak among themselves. Instead, they spoke in low and no doubt anxious whispers. 4733 says this: we would whisper in each other's ear because we didn't dare speak properly in case we were eavesdropped from outside. And another, 1448, remembered it in this way: we were not allowed to speak to each other. While lying crumpled on the hard floor, we used to talk in low whispers. In these proceedings, the voices of those who suffered at Kukës will be heard, even the voices of those who are now dead, whose testimony lives on in their statements and in the memories of their family members. From the perspective of the victims, this is one of the most important aspects of this court. Their harm will be recognized. The fact that they are victims will be recognized. It is no easy thing to be a victim in one of these cases. As this court has already acknowledged, there is a climate of fear and intimidation in Kosovo for those who agree to assist this court in its work. In Kosovo, some try to portray the victims of crimes committed by members of the KLA as traitors or collaborators. I want to say this on their behalf. These victims were supporters of the KLA, not enemies of it. The fact that they accused this member of the KLA, Pjetër Shala, is not in any way a condemnation of the KLA itself. The victims in this case suffered harm as a result of the lawlessness of Pjetër Shala and of others. It is not right that they be made to suffer again by being regarded as disloyal to Kosovo. They are no such thing. What do the victims want here? They want acknowledgement of the harm that they suffered, and my co-counsel, Ms. Radziowska, will address you more on that towards the end of this opening statement. But they also want a just outcome to this case. And in their view, a just outcome of this case is one that involves Mr. Shala admitting his guilt or that guilt being proved. His attitude is one of denial. But as you have already heard, and as he started to repeat this morning, it goes very much further than that. He claims that lies are being told about him, and because of that, we, on behalf of some of those whom he harmed, are going to take a little time to see if we can assist the panel with finding the way to the truth in this case. And we do so because the victims participating in these proceedings have a right to the truth. And so what I'm going to do next is to conduct an examination of some of the evidence in this case. And what we say about the evidence is this: when it's properly and fairly analysed, it's apparent who's lying and who's telling the truth here. The truth is that the evidence in the case implicates Pjetër Shala in a way that is only compatible with his guilt. But in order to do that, we need to look at the evidence in some real detail. And it is, I'm afraid, impossible to do that and to respect the protective measures that are in place. It's impossible to do that in open session. And so I would invite the court, please, to move into private session at this stage.
Madam Court Officer, could you bring us into private session?
Your Honors, we're now in open session.
Thank you very much, Court Officer. Hearing is adjourned. We will be back in a while.
All rise. All rise.
Please be seated. We are in public session, and the decisions of the panel with regard to what I'm going to say now can be done in public session, because I will not go to the content of anything regarding possible evidence. There are 2 points that have to be decided on now as far as the panel concerns. One is with regard to the objection to the content. That was a point made by the defense. The panel agrees with Victims' Counsel that the slides were notified in advance. There's a time limit in order to be able to react, and no reaction came. So in that respect, the objection is rejected. There is another point, Victims' Counsel, with regard to the opening statements being done in private or public. And the panel has made it clear several times in our email correspondence that the opening statements should be done as much as possible in public. And the division of the opening statement prepared by you, as is done now, is not, in the view of the panel, in conformity with that general rule we formulated. So what we will do, we will give you another 20 minutes to discuss what you wanted to discuss with regard to your presentation in private. We will then take a break, the normal break of 1.5 hours, depending on the moment when we will have finalized. Then the 1.5 hours will start, and then you will be given to continue the floor to continue with your opening statements, but in public.
Thank you very much for that. That's extremely helpful. I have 20 minutes to complete what I want to say in private session, and that will be wholly adequate. Thank you.
Okay, but as a general remark for the panel, I read differently when you said that there were 3 parts: a first, a second, and a third part. And when you said that the second part would be in public, in private, I had not expected that that would be an hour, and then there would be 5 minutes in public and 15 minutes or 10 minutes in public too. So I put it there.
We meant no discourtesy at all, of course, and I hope I made it very clear that the slides were all related to private session, and that's what I'm dealing with now, but I shall use the remaining time to deal with them expeditiously. Thank you.
Madam Court Officer, could you bring us into private session, please?
Your Honours, we're in public session.
Thank you very much. Victims' Counsel, it is my understanding, based on what you said at the beginning, before you started with your opening statements, that the last 10-15 minutes, your co-counsel would be dealing with the opening statements. Is that correct?
Well, that's correct. I have another 2 minutes to say in open court, if that.
No, because normally the break would be at 1. So
Yes.
if you don't, my proposal to have a break right away was in order to have you reorganize if you wanted to do something from private into public. But if that is not necessary, I propose that we proceed.
Yes.
And then I think we can finalize before 1 o'clock, including maybe, if I'm allowed by the interpreters, take a few minutes for 2 points, which are brief, but one is, I will discuss them, but they are brief, and then we could have the afternoon to do other important things with a view to tomorrow when we will have the defense opening statements. Yeah? That would be my suggestion. Yeah, I see nothing here. So, Victims' Counsel, you have the floor.
Thank you so much. In summary, then, the evidence will show that Peter Shala was one of the perpetrators at Cookish. The existence of this court shows that victims, if they have the courage, can and will be heard many years after crimes were committed against them, and that the perpetrators of crimes of this gravity are never, in fact, beyond the reach of the law. Those who were powerless then will now have the power. Those who were not allowed to speak will have their say. And with Your Honour's leave, I will ask my co-counsel, Ms. Radziowska, to address you further, specifically in relation to harm. Thank you.
Thank you, Your Honours. War crimes of arbitrary detention, cruel treatment, torture, and murder. These are the crimes that Mr. Shala is accused of. Victims of these crimes have been harmed tremendously. One has not survived the ordeal that he has been put through. And although these crimes took place more than 20 years ago, the harm and the suffering that they caused continue to affect people's daily lives deeply. Persons who were detained at the Cookies factory were not actively taking part in any hostility against the KLA. To the contrary, some of them wanted to join the KLA. None of the victims detained and mistreated at the Cookies factory was officially presented with charges, accused, or sentenced for a crime. Yet, they were detained and treated in most cruel, dehumanizing ways. Some of the victims were kept at Cookies facility for over a month. They were routinely beaten and mistreated, practically on a continuous basis. Description of what happened at the Cookies factory to some extent illustrates the harm endured by those who survived it and those who were detained there. They were beaten nearly every day and night with hands and feet or with various instruments, rubber buttons, wooden buttons covered in bandages, baseball bats, iron or metal bars, guns and other sharp objects, knives. Sometimes this mistreatment lasted all night. According to one of the victims, they used baseball bats and metal rods to hit him on his head, back, arms, and wherever else they could. Then he lost consciousness. He was covered in blood all over. They even put salt on his wounds and his eyes. That is not all. Some of the detainees were shot at, and then the beating continued despite the gunshot wounds. They were refused necessary medical care. Those detained at Kukës were also abused psychologically. First of all, they were exposed to the suffering of others. They could often either hear or see how others were mistreated. They were threatened with death or serious bodily injury. Some were ordered to beat their co-detainees and heavily beaten when refused. To be clear, this description of tools and methods of mistreatment that victims suffered from at the Kukës factory is far from exhaustive. We can only try to imagine what impact this mistreatment has had on the lives of those who survived it. And it is difficult to find the words that would do justice to the harm they suffered. Years after, when asked directly about consequences of his mistreatment at the Kukës factory, one of the victims described succinctly that he has pain in his leg, wounds, broken rib injuries, bone pains, headaches, spinal disc pains. He suffers from stress, loses his temper quickly. He has frequent flashbacks of the mistreatments he suffered at the time and does not sleep well. He says that fear is stuck in his head. He bitterly resents the portrayal of him as a traitor by those who mistreated him and said he was a collaborator, while he was not. He struggles to find his place in life. I'm in the middle, neither on the land, neither on the sky. That's what he told us when we met him. It's clear the trauma of these events has never left him, and probably it never will. The crimes that occurred at Kukës factory have also affected the lives of those who have never been inside the facility. Those whose family members were detained and tortured there, even to die. Today, they cry when they speak of these events. They speak of trauma and distress when their family members were arrested. They speak of trauma and distress that they felt when the family member returned from Kukës. They speak of loss that cannot be regained. Even though their family member survived his ordeal at the Kukës factory, physically, he came back as a different man. The years passed, but the person they knew before Kukës never came back. They speak of social stigma resulting from these events. The stigma prevented them from attending school, finding a job, but also aimed at intimidating their attempts to seek justice for what happened. And Your Honors, it is important to explain that the relatives of those who were detained and mistreated at the Kukës factory, they're not prone to speak about themselves. They do not dwell into their own suffering. At the same time, upon meeting them, one can immediately sense that still today they're deeply overwhelmed by what happened to their loved ones. It is illustrated not necessarily by words, but rather by tears and by their persistency to learn what happened and for what reason. In the course of this trial, we will hear victims and witnesses speaking of the impact that the crimes charged in this case have had on their lives. Without these accounts, it is impossible to draw a full picture of what happened at the Cookies factory and to comprehend the gravity of the crimes committed there. Your Honor's determination, recognition, and acknowledgement of the harm suffered by victims of these crimes is an important objective of these proceedings. What matters most to victims is finding what exactly happened, for what reason, and who was responsible for it, and the ability to take part in these proceedings in which their harm will be finally, publicly recognized and acknowledged. Thank you, Your Honors. This completes our submissions on behalf of victims.
Thank you, Victims' Counsel. This concludes the opening statements for the Specialist Prosecutor's Office and the Victims' Counsel. We will hear tomorrow the opening statements by the defense, followed by an unsworn statement of Mr. Shala. Before we will conclude today's hearing, there are two issues I would like to discuss with you. One concerns the SPO request filed on the 13th of February of this year for video conference testimony for three witnesses. For three witnesses, that suffices for now. That is filing 425. We have asked by email to the defense and Victims' Counsel to confirm by the end of the first session of today's hearing whether they will be in a position to respond to the SPO request orally. We have informed, the defense has informed us by email already yesterday at 15:43 that it is not in a position to do so and will proceed to file written submissions on this matter. Following the time limits prescribed by Rule 76 of the rules. However, I would like to ask Victims' Counsel whether they intend to respond orally in court to the SPO request tomorrow, or whether they will also file written submissions.
Well, I can respond orally tomorrow, or I can respond orally today. Very happy to say that we have no objection to the course that is proposed by the SPO.
Thank you for that. However, in this respect, because there will be written submissions, I propose that the Specialist Prosecutor's Office files their reply, a written reply to the SPO following Rule 76. We tried to avoid a written decision, but I understand that it's a busy moment at the moment. Nothing else to add from...
No, Your Honor, we understand. We'll file a reply if needed once we have the defense response.
Okay. Very well. Then there is a second point which regards scheduling, and it is specifically the SPO I would like to direct my request to. We are considering to add, if parties and Victims' Counsel are available, two extra dates, one extra date and a swap of dates for hearings in case 04. And the additional dates could be Friday 19th of May and Friday 16th of June of this year. And we would like to discuss the following with the parties and Victims' Counsel and the registry tomorrow after the opening statements by the defense. And we would like to hear from the SPO if it would be possible to call witnesses on those dates. And it should be witnesses, maybe expert witnesses. There is also a witness which is estimated for 2 hours, because it should be concluded in one day. because both the 19th of May and the 16th of June would be a sole day. And the 16th of June would be instead of the 30th of June. Yeah, so the 19th of May would be an additional day, and the 16th of June would be a swap day. And now, we, as I said, the panel was considering the possibility of an expert witness or a witness that is calculated for a limited amount of time, but we leave it, of course, to the SPO to decide if it's feasible and who should that be, and also the availability of the witness. I mean, there are a lot of factors to be taken on board in deciding that, but the panel is trying to make the best use of the available days we have before the judicial summer recess. And the calculation, a goal could be, a purpose could be to have the SPO case finished before the summer. Let us see, but my proposal is to use to the utmost what we have at our disposal. So my proposal would be if you could look into that, and any further observations by the Defence and Victims' Council in this respect and the registry tomorrow after the defence opening statements will be more than welcome. Yes? Okay, very well. I will do a tour along the Specialist Prosecutor's Office. Is there something that you would like to bring up?
Nothing
No?
at this moment.
Very
Thank
well.
you.
Victims' Council, is there something?
No, thank you, Your Honour.
Very well. Defence Council.
Thank you for the opportunity, Your Honours. Sorry, just to, my apologies. I would like to put the correct last name of my colleague, and my apologies to her, who is attending, because I had difficulty pronouncing her last name earlier. So I'll try to do it now, if you allow me. Thank you very much. It's Ms. Zeynep Yani Komeroglu. Thank you, Your Honours.
Thank you for that. This concludes today's hearing. The hearing is adjourned. We see each other tomorrow at 9:30.
All rise.